Okay, let's unpack this. Imagine this scenario. You're renting, right? And, well, things aren't working out, maybe friction with the landlord, whatever, and you desperately need to move before your lease is actually up.
Yeah, a situation a lot of people find themselves in.
Exactly. Breaking the lease might have consequences, maybe there's a penalty involved, but then your landlord hits you with it. They're keeping your entire security deposit, every single cent.
Oh,
Can they actually do that? Just unilaterally decide to confiscate the whole thing? This deep dive is definitely for you, because the answer, well, it might not be what you think.
it's an incredibly common situation, isn't it?
Mm-hmm.
And it causes huge amounts of anxiety. You feel trapped, maybe a bit bullied, and that lease document feels like this unbreakable law.
Totally.
But like you said, the reality, according to the sources we looked at, it's it's more nuanced than that.
Absolutely. We're diving into source material that really digs into this exact tenant-landlord battleground, specifically, early lease termination and this whole security deposit standoff.
Right.
Our mission here is to cut through that feeling of helplessness, understand the tactical principles the sources reveal, and give you clarity on your rights and how to navigate this based on these insights.
And we should probably use a case study from the material to ground this, make it real. Let's look at a hypothetical tenant. Let's call him Mr. Lai.
Okay.
Mr. Lai is in a shared apartment, but he's experiencing some friction with his landlord, and he feels he just needs to terminate his lease before it officially expires.
So, classic scenario. He checks his lease, and sure enough, there's a clause. It explicitly states he cannot terminate the lease arbitrarily before it expires. Standard stuff, maybe.
Pretty standard, yeah.
But based solely on this one line, the landlord informs Mr. Dai that if he leaves early, the entire security deposit is gone. Just confiscated as a penalty?
Right, and Mr. Lee, he's not trying to shirk responsibility entirely. He gets that leaving early is technically a breach of the contract.
He understands that part.
Yeah. But he's left with two really critical questions, and they get right to the heart of this whole thing. First, does the landlord have the unilateral right to just say, yep, keeping the whole deposit based only on that no early termination clause?
Just based on that one sentence.
Exactly. And second, what if the reason he's leaving early isn't entirely his fault? If the dispute involves some responsibility on the landlord's side too, does that change whether the landlord's action is justified or even reasonable?
Those are the million-dollar questions, right? Because landlords so often seem to default to, you broke the lease, I keep the deposit. Simple as that.
It's the easy route for them, perhaps.
But our sources indicate that's just not always the full picture, legally or, tactically speaking.
And what's particularly insightful here is that the sources point directly to a key official interpretation. This isn't just like someone's opinion. It's guidance from the Ministry of Interior.
Oh, okay. An official interpretation.
Yes, there's even a reference number. This provides some really crucial practical clarity.
Okay, that's where it gets really interesting, an official interpretation. So what does this guidance actually say about Mr. Lai's situation and people like him?
Well, it starts by confirming this principle of contractual freedom. Basically, what you agreed to when you signed.
Okay, freedom of contract.
Right. So if, at the time you signed the lease, you and the landlord agreed the lease couldn't be terminated early, you could, and ideally, should also have mutually agreed on liquidated damages for that early termination.
Ah, so the ideal scenario, the tactical gold standard the sources suggest, is having a clause that doesn't just say you can't leave, but one that explicitly states the specific amount or the calculation method for that penalty.
As I see.
Like if the tenant terminates early, they pay damages equal to, say, 2 months' rent. Something concrete.
Exactly. That makes everything clear up front. It's a mutually agreed upon consequence. But what about Mr. Lai's case,
Yeah.
and probably many others, where the contract only says cannot terminate early, but is completely silent on the amount of liquidated damages?
Right. The agreement says no early out, but there's no actual number attached to breaking that rule. What then?
And this is where that Ministry of Interior interpretation provides the critical answer to Mr. Lee's first question. No.
Yeah.
Absolutely not.
Yeah.
The landlord cannot unilaterally decide to just confiscate the entire security deposit based solely on that general no early termination clause when no specific amount was agreed upon beforehand.
Wait, seriously. So just having no early termination written in the lease doesn't automatically mean the whole deposit is forfeited if you leave. That feels honestly counterintuitive to what I think many people assume.
It really does, doesn't it?
Yeah.
And that's why understanding this interpretation is so powerful for tenants. If the contract hasn't preset the liquidated damages amount,
Yeah.
that figure must be mutually agreed upon by both parties
Right.
at the time of the early termination. The landlord doesn't just get to make a unilateral decision and grab it all.
So they can't just dictate the penalty after the fact.
Exactly. And remember, the security deposit's main job, its core function, is to cover things like rent arrears or repair costs for damages when you eventually move out.
Right. Damages you cause.
While it can be used to offset reasonable liquidated damages for breaking the lease, this doesn't magically give the landlord arbitrary power to decide what that amount is or just take the whole thing.
Okay. Okay. So if the contract is silent, it has to be a mutual agreement. But that brings up the next question. What counts as reasonable damages in tactical terms? If you're negotiating, how do you even approach putting a number on it?
That's a great question. The sources explain that in practice, especially if the situation escalates towards, say, formal dispute resolution.
Like mediation or court?
Yeah, the amount is often assessed based on the landlord's actual losses, things they can actually point to.
Actual losses. You mean like money they can prove they lost because you left early?
Precisely. This usually means rent loss during the period. The property is genuinely vacant while the landlord is actively and reasonably trying to find a new tenant. The sources call this empty period loss.
Okay, so the time it realistically takes to re-rent it.
Yes. And it could also include necessary and reasonable costs directly tied to re-advertising the rental. The cost of putting up listings, things like that.
Got it. So it's about compensating them for the verifiable direct cost of finding a replacement, not just some arbitrary punishment fee.
That's the idea. And the sources do note that while 1 month's rent is sometimes used as a kind of reference point in practice, maybe in negotiations,
Like a starting point.
maybe, but it's absolutely not a fixed legal rule or a cap. The final reasonable amount always depends on the specific circumstances of that individual case. How quickly was a new tenant found? Did the landlord drag their feet? How much did they actually have to spend on advertising? Was it reasonable?
That makes a lot more sense. It adds a layer of factual assessment instead of just the landlord pulling a number out of thin air or just taking the whole deposit regardless.
Exactly.
Now, let's tackle Mr. Lai's second key question. This feels really important, the one about shared responsibility.
Mm.
What if the dispute, the thing that pushed him to leave early, actually involves some fault on the landlord's side too? This seems like a crucial tactical consideration.
Oh, it fundamentally changes the picture. That same Ministry of Interior interpretation also clarifies something else important, even with that no early termination clause sitting right there in the contract.
Yeah.
A tenant still has the right to legally terminate the lease under specific circumstances defined by law. Or if fulfilling the contract just becomes factually impossible through no fault of their own.
Wait, so the contract clause isn't the absolute final word if the landlord isn't holding up their end of the bargain. There are actual legal outs for the tenant.
Precisely. The contract doesn't override certain fundamental tenant rights or landlord obligations.
And where do you find these legal outs? Are they hidden somewhere?
Not hidden, but you need to know where to look. Typically, they're found in related regulations, like the standard contract terms for housing leases, which often have the force of law, depending on the jurisdiction.
Okay. Could you give us an example? Like, when might a tenant have this legal right to break the lease, even with that clause saying they can't?
Sure. Common examples include significant defects in the rental property. We're talking major structural issues, serious safety hazards, or problems that make the place genuinely unusable for living.
Like no heat in winter or major leaks?
Exactly. Things the landlord fails to repair within a reasonable time after the tenant has properly notified them. That notification part is key.
Right.
Another example is if the landlord breaches crucial contract terms themselves in a way that fundamentally prevents the tenant from getting what they bargained for in the lease. Like, if you rented a place specifically because it had guaranteed parking and the landlord suddenly takes that away and won't fix the situation.
Ah, I see. So if Mr. Lai's dispute, the reason he wanted out, actually fits one of these statutory termination grounds. Let's say the landlord refused to fix a dangerous electrical problem despite repeated written requests. He might not only have the legal right to terminate early, but could potentially do so without paying any liquidated damages at all.
That's the powerful tactical implication, yes. If his reason for leaving is legally justified because the landlord failed to meet their obligations, it essentially removes the landlord's basis for claiming damages for the early termination. They can't penalize you for leaving because they made it necessary or impossible to stay.
Wow, that's a massive difference. From potentially losing the entire deposit to potentially owing nothing, purely based on whether the landlord messed up significantly.
It really highlights the importance of understanding not just your obligations, but the landlord's too, and these potential legal grounds for termination.
Okay, but what about the gray area? What if the dispute isn't quite severe enough to meet those formal statutory termination standards?
It's bad, but maybe not quite legally uninhabitable. But the landlord does clearly bear some responsibility for the problem. Not a full legal out, but definitely some fault on their side.
That's a very common scenario, isn't it? The situation is tense, the landlord contributed to it, but maybe it doesn't tick all the boxes for a statutory termination.
Right. So the tenant is still leaving early, which is technically a breach on their part, but the landlord helped create the mess.
In this more common gray area, even though the tenant's early departure is technically a contract breach, the landlord's partial fault becomes a very significant practical advantage, a negotiation chip for the tenant.
Leverage, basically. You can use their actions against them in the negotiation.
Exactly. The tenant can use the landlord's contribution to the dispute, hopefully documented, to argue forcefully for a reduced amount of liquidated damages. It undermines the landlord's claim to the full penalty.
Makes sense. And if the landlord still insists on confiscating the entire deposit in that situation, their position becomes significantly weaker and, frankly, much less reasonable, especially if things were to escalate to mediation or some kind of formal review.
So, shared blame really weakens the landlord's claim to the full amount. It transforms the conversation from a simple, you broke the lease, you pay the max, to something more like, okay, yes, I'm leaving early, but your actions or failures contributed significantly to this situation, so the penalty needs to reflect that reality.
That's precisely the tactical shift in perspective, yes.
Okay, this has been incredibly clarifying. Based on everything we've unpacked from these sources, let's try and distill some practical, tactical tips for you, the listener, if you find yourself in a similar situation or even just want to be prepared for the future.
All right, let's turn all this insight into some actionable steps.
Okay, first, the starting point tactic. You absolutely have to pull out that rental contract and read it thoroughly. Don't just skim it. Look specifically. Beyond any general no early termination clause, is there a clear pre-agreed section on the amount or the calculation method for liquidated damages if you do leave early?
Know exactly what you signed.
Yes.
Yeah.
This is the absolute bedrock for figuring out your next steps. Don't assume what it says. Verify it.
Because that determines if the landlord even might have a basis for demanding a specific amount or if it absolutely has to be negotiated based on actual loss.
Right. Okay, second, the core tactic. You need to objectively assess the nature of the dispute that's making you want to leave. Is it just annoying, or does the issue you have with your landlord potentially rise to the level of a statutory ground for early termination?
Be honest with yourself about the severity.
Think. Serious defects the landlord won't fix. Major breaches of the lease by the landlord. And crucially, gather and preserve all your evidence. Messages, photos, repair requests you sent, emails, inspection reports, anything that documents the problem and your attempts to get it resolved.
Paper trails are golden. Evidence is your best friend in any dispute.
Couldn't agree more. You need to know if you might have a strong legal argument to walk away with minimal or even zero penalty.
Knowing your potential legal standing is key.
Absolutely. And third, the execution tactic. Initiate rational negotiation with the landlord. Try to approach this conversation calmly, but be firm. You're armed now with your understanding of these principles.
Knowledge is power here.
Clearly state that if the contract doesn't preset those liquidated damages, the amount is subject to mutual agreement based on reasonable actual losses. It's not their unilateral decision to just take your whole deposit.
Set the correct framework for the discussion.
Yes. And if the landlord does share responsibility for the situation leading to your departure, use that documented fault as leverage. Use it to negotiate a mutually acceptable outcome, which, based on everything we've discussed, would likely be a significantly reduced amount compared to the entire deposit. Maybe even zero, depending on the circumstances.
Be informed, be prepared, be reasonable but firm, and understand the actual legal and practical principles at play. Don't just accept the first thing they say.
You know, this deep dive into the sources really shows us that the presence of a simple no early termination clause is. Well, it's far from the end of the story when it comes to your security deposit.
It's just the starting point of the conversation, really.
Yeah. There are these layers of legal interpretation, factors like actual provable losses, potential statutory rights for the tenant, and this whole concept of shared responsibility that fundamentally change the dynamic.
It really highlights the strategic power that comes from understanding the specific regulations and interpretations that govern these seemingly rigid situations. It's not always as black and white as the lease might make it seem.
It truly transforms what feels like a landlord dictated penalty into a situation with shades of gray and importantly, actual room for informed negotiation and protection of your rights as a tenant.
Definitely. Gives you back some agency.
So, reflecting on this analysis, what really stands out to you the most? How does knowing these tactical points maybe change the way you might approach reviewing your next rental contract? Or perhaps, how does it reframe how you'd handle a potential dispute if one ever came up?
It makes you read the damages clause much more carefully, doesn't it?
For sure. Maybe the real takeaway here isn't just the specific rules about deposits and clauses, but something broader, like how gaining precise knowledge about your rights and the actual legal landscape can empower you in situations where you might otherwise feel completely powerless, just stuck accepting whatever the landlord says.